American Lithuanian Naturalization Club of Athol versus the Board of Health of Athol.
Thank you. Mr. Bantham.
Thank you. Good morning. Christopher Bantham, co-counsel for the town of Athol. This case is here today on direct appellate review from a decision in the Worcester Superior Court striking down a Board of Health regulation relative to secondhand smoke in charitable club facilities. The Athol regulation is a reasonable regulation because it reduces the likelihood of the numerous adverse health effects caused by secondhand smoke, lung cancer, heart attack, stroke, asthma attack. The legislature, in passing Chapter 270, Section 22, which is the statewide secondhand smoke law, envisioned and specifically allowed for regulations like the Athol regulation. Chapter 270-22 creates a two-tiered regulatory scheme for secondhand smoke. At the state level, Chapter 270, Section 22 sets the standard. At the local level, municipal regulation, bylaw, or ordinance sets the standard with one caveat, that the standard be equal to or stricter than the state standard.
Doesn't the statute flat out say that the local authorities can regulate smoking? I mean, am I reading the wrong thing? 270-22 sub J says nothing shall permit smoking, blah, 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 which is hereafter prohibited by law, including any other law, ordinance, and so forth.
That is correct, Your Honor. It establishes...
So what the hell what can be more clear than that?
Good question.
Well, that doesn't authorize Board of Health to do anything. It just says if, in fact, the Board of Health is authorized to limit smoking in some other respect, this law doesn't trump that, as long as the restriction is greater than the state law.
This law tracks what is common amongst our health and safety laws in Massachusetts. For example, in the distribution of alcoholic beverages, the state establishes one standard allowing for stricter regulation at the local level.
So your authority comes out of your Board of Health authority, which is
Chapter 111.
Chapter 111, Section 31. That's where your authority comes from.
That is one source of authority, and that source of authority defines the scope of Board of Health authority as such that the regulation must be reasonable
Assuming
and must
that
be
we
related to health.
agree with
Yes.
you, what about the fact that if you adopted, that carrying your argument to your logical conclusion, you could prohibit smoking in all the 9 areas exempted by the legislature in that Section 22? How do you answer that?
If the club members believe that the Athol regulation infringes upon their privacy rights, their recourse is to challenge the constitutionality of the regulation. But every federal and state court that has looked at that question has determined that smoking, which is the issue here, does not warrant heightened constitutional protection.
I don't know that you answered my question. My question is that if we accept your argument that the statute permits the local boards to regulate smoking further, in other words, the statute is just a floor, and you can go above it, which is a reasonable argument. But what if you adopted regulations that would prohibit smoking in all the 9 areas that had been exempted by the legislature? You know the 9 I'm talking about?
Yes, I
Private
do.
homes,
Okay.
you could
Yes.
presumably, your argument,
Thank you.
taken to the limit, is that the Board of Health could, in essence, ban smoking in the town, because smoke is released into the air, people breathe air, and therefore it could ban smoking in the town.
Would you be
Yes.
voiding the statute, in effect, is my
No,
question?
you would not.
No, would the Board of Health be voiding the statute by enacting regulations that wrote out all the 9 exceptions?
There is a chance that a local regulation might violate a constitutional right if they were to regulate in a private home, if they were to regulate smoking as part of a religious ceremony. These are examples of the exemptions. Probably not if they said no cigar bars or no smoking retail stores, but there's a chance that that might occur.
Why
The
isn't a
test-
private club the same thing as a private house?
It's
I
very
mean,
different.
These people, you know, they join, they pass membership tests. It's for them, and all other private clubs, it's sort of an extension of their house. And you just said you can't ban smoking in the house.
I believe I said that there's a chance, in looking at the specifics of a regulation related to smoking in the house, that it could violate the Constitution. In response to your argument...
Well, forget the Constitution. What about just, you know, can the board just ban it in a house?
We have not reached a conceptual boundary to Board of Health authority in this case. The charitable clubs are more like commercial establishments than one's home. They are pervasively regulated at all times, whether they are closed to members or not. The alcohol distribution, the storage, the handling, the service of food.
But it's one thing to regulate, it's another to prohibit. I mean, that's the extreme form of regulation. Thou shalt not thou shalt between 6 and 9 at night only, or only when members, or prohibited when non-members are in the club, or when the club is being rented out for various other events. I mean, that's regulation. Prohibition is something different.
There is, if I may respond in two ways. First, there is no scientific doubt that the only way to eliminate the harm from environmental tobacco smoke is to ban smoking. Ventilation does not solve the situation. That's a scientific fact.
But these people are adults. Why don't we let them vote, and their membership vote on what they want to do, and keep the Board of Health out of it? I mean, after all, it is a, quote, lawful activity, right?
But we don't, we delegate duties such as passing regulations for health to a board that is supposedly has expertise. That's why we give weight to the expertise of the board. We don't have everybody vote on every regulation. That isn't how we run government.
Yes, and in addition, assuming the risk of an activity cannot stand as a defense to a public health law, as I point out in my responsive brief. If we are to allow assumption of the risk as a defense, then our seatbelt laws, our helmet laws,
but that seems to me quite different, because frankly, it would presumably the state can say if you want to drive on a public road, you have to comply with certain regulations. If you are riding around in your backyard, I'm not sure the helmet law would apply.
There are state health and safety laws that do apply to the private homes, and there are many cases in which
if you want
you can't smoke.
If you want to put a nightgown on a child that you are putting to bed in your private home, you have to have flame-resistant material, correct?
That may be correct, yes. And in child custody matters, whether someone smokes or not bears on the custody rights to a child. So there are examples
Is there one case where we have said that a Board of Health can prohibit smoking in a person's private home?
Not to my knowledge, except to the extent that
Is
there's a
there
business.
any case in the whole country?
In a private home?
Yes.
Is there any
during
regulation that is
when there's no
prohibited in a
business?
private home to give rise to any case?
I'm sorry, could you...
Is there any regulation prohibiting smoking in a private home so that we would even have ever had such a case?
That, I believe, is the case. I don't think the Board of Health is...
We've never gone, nobody's regulation has yet gone that far.
And we have not, in this
So we
case,
don't
reached
know.
that conceptual boundary
I
of
take
Board
it
of
that
Health authority.
I take it it's your position that the applicable regulation, which is 661.0 something,
The
that
Department
says
of Public Health regulation.
right, that
Yes.
says smoking shall be permitted, and then, you know, it talks about private clubs, that is not intended to actually outlaw or prevent a local Board of Health from not permitting it. Is that your position?
Correct. It mirrors the state law in that it also includes
It just says,
an
look, you guys
invitation
can
for boards to go further.
you guys can do nothing and it's permitted, or you can pass an ordinance and permit it and maybe limit it in some ways, or you can do what Athol did here, which is bar it.
Correct.
Is that your position?
That is.
And how do we test in those circumstances the reasonableness of the regulation? I mean, you've suggested there's some outer constitutional limit. There's a suggestion that if the Board of Health said, nobody on their private property in their private home, that's not this case, but how do we, what's the standard by which we test the reasonableness of the local board's regulation?
First, I think the question of reasonableness is one that we should defer to the local regulatory bodies, in this case, the Board of Health.
We can't have a system where if the board says it's reasonable and it's not. I mean, tell me how I look at that question.
I think the best way to look at that question is to examine the facts in the particular case, to look at other regulations at the local level that have been upheld or that are common, and measure it against those, to look at the regulation and see if it achieves the
Well, we
outcome
make private
desired.
clubs comply with the sanitary code and with the alcoholic beverages licensing law. So what's the difference once we decide that if this regulation is health-related and it's reasonable because it's aimed at protecting the people who visit and who work at the club, then what's the difference, then what is the difference between this regulation and the others?
I think they're exactly the same. These regulations apply at all times to protect guests, workers, and the members of the clubs as well. So does the Athol regulation.
Well, I mean, part of your argument is environmental smoke that affects innocent third parties, but the other part of your argument is that any time the Board of Health determines that something is dangerous to the health of any individual, it can regulate that conduct. Isn't that your argument?
There's a potential for regulation if there is a threat to the public health, if there's a
Well, you said to any person's health. I mean, that's what your brief says. Because the argument on the other side is, yes, you are limited to regulating issues of public health, not private health, not personal conduct.
Every public health law affects individual conduct, quarantine laws, vaccination laws, helmet laws, seatbelt laws. The public is made up of individuals, and it is the aggregate of individual conduct and individual health that defines our public's health.
You could put out a public health regulation saying homes have to be equipped with carbon monoxide detectors.
Which they are suggesting, the legislature is suggesting right now.
Right now. I mean, and that would be to go in people's private homes just to protect them from carbon monoxide poisoning, right?
That is, yes.
Well, what about this? There's a tremendous amount of research now done, of course, it's been around for a long time, that foods that have high levels of saturated fat are very dangerous to your health of your heart, and heart disease is certainly probably the leading cause of death in the United States. And what's the limiting principle here? If your board says, red meat it's got a lot of saturated fat, we don't really think people in this town ought to eat red meat because it's a public health issue. We're going to ban red meat in restaurants. We're going to ban it in homes. Now, I don't like red meat, so I'm not a red meat eater. But where's the limiting principle here?
The limiting principle are we don't know all the facts on these foods. Red meat is, let's take another example. Fast foods, for example. Okay. We don't know the intent, what the fast food manufacturers have done. They very well could have. We just don't know.
Isn't that whole area preempted by the Food and Drug Administration of the federal government? So we're not talking.
That could establish a limitation for it. I'm not quite sure. Yes.
Can I just go back to my original question, which I think is the import of all of these questions? There's no question that we regulate private homes. For example, every condominium in the state has to have a smoke detector.
Every home, yes.
Has to have a smoke detector. Is there any basis to say this non-criminal conduct, the Board of Health can say, this happens to be a private club, but the Board of Health could say, nobody may smoke in their private home in Athol? I mean, you say to me there's a floor, but we can impose greater limitations.
If
I
may-
know it's not this case, but is there any difference between that? You're going to say, well, that's ridiculous. The board of, the mayor would be thrown out of office. Leaving that aside, what is the difference between that, if any?
The difference is that perhaps an expectation of privacy. The Board of Health Authority could very well include that scenario, but
You're saying to
if
me
you
that
search
a
for-
regulation under this statute, unless there's a constitutional challenge, and you don't have to address that, but the board can simply promulgate a regulation that says in any private home there will not be smoking.
I think they would first find it unconstitutional.
Why?
So would not do it.
Why?
Because,
We put smoke detectors in. You've got to put smoke detectors.
and we also prohibit police officers from smoking at all times, even in their homes. But Perhaps they could, if I may.
Let me put it this way. If you are uncomfortable with that, and you might be uncomfortable with that, why are you comfortable with 10 people getting together in their own little private club?
because in looking at the facts and the situation and how private clubs operate, people don't come to private clubs to enjoy the privacy that they have in their home. People come to meet others for camaraderie, to carry out community events, and they know that they are pervasively regulated in many ways. So in that sense, a private club is very different from a home.
Well, so when the Order of the Moose goes to John Jones's house, 50 people go there every Monday night to smoke. Can that be regulated?
If all the membership of a club goes
The club doesn't
to,
own a building. There are lots of private clubs. They don't own buildings. There's a group of lawyers that get together once a month. They get together in somebody's private home. They
In
get
that si-
together for camaraderie. They get together to talk about the latest decisions of the Supreme Judicial Court and why they always agree with them.
And to smoke cigars.
in that situation,
Isn't the answer to that hypothetical that clubs require certain state licenses, alcoholic beverage licenses?
Exactly. In that situation.
So therefore, once you get into state licensing requirements, which obviously aren't involved in your own house, you don't have to have a liquor license to drink in your own house and so on, you're in an area of state regulation.
Correct.
Or government regulation, so...
Does this apply only to private clubs that have liquor licenses?
No,
So you could have a teetotalers private club that it doesn't have any license. It's just a group of teetotalers getting together every Thursday night.
if they get together in a private home and they are not organized under
No, they
the
organize.
corporate laws
Oh,
of Massachusetts to be a private club, then
No,
they would be exempt from
No, they do. They're a
regulation,
Chapter
but-
180
but-
corporation. They go out and they have a pancake breakfast every summer, and the proceeds go to some charitable organization.
There are,
They don't have a building. They go to a different person's house every Monday night.
or they go to a different church basement or to a different...
but if they don't act like a charitable club, like the clubs in this case, if they act more like a group of friends getting together,
No, they're a
even if
charitable
they-
organization. Chapter 1, as Justice Skinner said, they're incorporated, they have limited liability because they don't want to be sued if their pancakes flip over. I mean, they're a club.
if they wanted to, in that situation, serve alcohol, they would have to get a license.
No, but
If they
I take
wanted
it you argue...
Well, you could answer that by saying by necessity of getting a state charitable charter under Chapter 180,
That's a
they
form of
subjected themselves to state regulation.
Yes.
I have another question on the conflict of interest situation that is raised here. That was not adjudicated below, isn't that correct?
That's correct.
Does the record enable us to decide that question up here? Are there undisputed facts on that issue?
The facts stipulated in the case do not address that.
Well, if we decide in your favor, doesn't something have to be done with that issue, correct?
Yes,
And what-
as I've argued in my brief, someone's political affiliation, who stands not to gain at all personally in a monetary way, does not rise to a conflict of interest.
Okay, but what do we do with it procedurally, since it was not adjudicated below, and since the facts stipulated, according to what you just told me, don't address that issue? if we agree with you, do we send it back to the judge, to the Superior Court to make, to adjudicate that particular issue?
I think if there are...
The facts, in other words, we don't know what the facts are on that issue.
We do not know what the facts are. The facts
Okay.
were stipulated in the trial court's decision. There are no facts in the records. There are one or two, but perhaps not sufficient to fully address that question. I
Okay.
will address it in my brief, however.
Is this case only a case of statutory interpretation?
It is primarily a case of statutory interpretation. Constitutional questions were raised at the trial level, but not reached in the decision.
And they haven't been raised on appeal.
No, that's correct. They've not been waived.
Right.
The constitutional issues are not raised on appeal?
Not raised on
No.
appeal.
Okay.
The answer is no.
I'm sorry, not waived. I do argue them in my brief.
Oh, you do?
Oh, you are.
Yeah.
Okay.
Thank you, Mr. Bantham. Mr. Clembley?
Morning, Your Honors.
Okay, can you first just address that last issue? Are the constitutional issues, have you waived them on appeal?
I did not waive them on appeal, Your Honor.
Right, so they're
but-
before us.
But I did not stress them.
I know.
You raised them?
But you,
I
Do you argue them?
raised them in a footnote, Your
Well,
Honor.
then, I mean, maybe
won't
I
do
didn't
you-
read every footnote, but in
A
which
footnote won't do you much good.
I mean, I really didn't see them, and maybe I...
Is that considered adequate appellate argument, a footnote?
Is it a long footnote?
It was not a long footnote, Your Honor. What I did was I
Does
incorporated...
it cite any cases?
I incorporated the argument that I made in the Superior Court, which was fully incorporated in the record, Your Honor.
Okay.
So the cases are cited and things are discussed. But I really want to focus on the last question. I think it was Justice Spina that said, isn't this really boiled down to a case of statutory construction? And that's what it is, Your Honor. This is a simple case of statutory construction. The source of power for the Board of Health to operate arises under Chapter 111, Section 31. And the source of specific authority to regulate in the area of smoking arises under the new statute, Chapter 270, Section 22, the Smoke-Free Workplace Law. All of the actions of the Board of Health of the Town of Athol have to be measured against the yardsticks of those two statutes. First of all, Chapter 111, Section 31 says that boards of health are authorized to make reasonable regulations respecting public health. And the two most important words of that statute are reasonable and public. The question is whether or not a regulation banning smoking in a private club is aimed at protecting public health, or is it in fact aimed at regulating private health? Is it telling people smoking is bad for you, don't smoke?
but what about regulations, state sanitary code regulations?
Those are regulations that truly should be imposed in a club if it has a kitchen. And
No,
if
but
it-
they're imposed
But they're
on
imposed on
homes
private
and...
homes as well.
They're imposed on private homes, and so that seems to counteract your argument.
No, sanitary code regulations concerning things like septic systems in a private home, of course that affects the public
Now,
at
what about
large.
smoke detectors in homes?
Smoke detectors affects every member of the community.
No.
How about
If it's a
carbon
private home,
monoxide detectors?
if it's a
Carbon
private
monoxide
home, yeah.
detectors, it's just protecting the people who are there. Would it be impermissible, in your view, for the town to pass a regulation that said every private home, every building, including private homes, has to have a carbon monoxide detector?
No, I don't think so. And the reason why is because it's a reasonable regulation, and it's reasonable because of the way that
How
they
is it
implement
public?
it.
You're claiming that if it's regulating something that's within the confines of a private club or a private home that doesn't affect the public at large, that just affects the specific people there, that is no longer public. And that's the part of your argument that I'm troubled by. That would suggest that smoke detectors and carbon monoxide detectors or other dangerous products can't be banned from people's homes. I think they can.
The mechanism by which the boards of health and the state statute imposes or enforces the smoke detector law at the present time is upon the sale or transfer of a home. When you go to a home closing, somebody's got to show up with a smoke detector certificate. Somebody's got to call the fire department. Some fireman has to come to your house, test the smoke detectors, make sure that they're on all the proper levels. And that's the one and only time that the government
I'm not asking
gets into
how
your
they
home.
enforce it, but there's a regulation that requires it to be there. And you're acknowledging that comes within the rubric of public health.
Yes, but it only has to be there one time, and that's when you move in. I could pull those things out today, and nobody could charge me with a crime.
But the sanitary code regulates every aspect of rental apartments. Now,
Because the public at large has to have a place to live by necessity.
yeah, but they're all private homes, once the apartment is rented, but the room's got to be a certain size, there can't be any lead paint in there, the bathroom facilities have to be such and such. You know, you've been through that code. The housing court is busy every day dealing with violations of the sanitary code. According to your argument, the landlord could say, hey, I'm a private landlord, they're private tenants, I don't have to obey the sanitary code.
Well, that would impair the right of a member of the general public to go out and shop for an apartment. Everything should be able to compare apples to apples. It should be a level playing field for every tenant to compare every apartment.
Mr. Tremblay, that is correct, but we also regulate condominium.
Right.
Sure, and we regulate building codes to make sure that the floor here is properly structurally sound for members of the public to come in here and not fall through the floor.
I understand the issue that, tenants or maybe even condo associations or certainly buildings, restaurants and so on, where the public comes in. And I take it the gist of your argument is you can't regulate in a private club any more than you can regulate in a private home.
Exactly right, Your Honor. And the reason gets back to reasonableness.
Can I ask you this? To what extent do you think that there's any basis for saying that any club that engages in any respect in any state licensing, state incorporation, in other words, not just an informal association of people getting together on Monday night, but to the extent that you invoke in any respect any state protection, privilege, immunity, or anything else, you thereby subject yourself?
That's an outstanding analysis, Your Honor, but the problem here is that this regulation regulates any type of private club. The ladies' quilting club meeting at someone's house on Wednesday nights would be regulated under this regulation.
Okay, but is your client an incorporated entity?
I have three, Your Honor. One of them, the American Legion, is chartered by an act of Congress. So they have privileges that they're entitled to under state law without being organized under Chapter 180 or any state organization. The other two are chartered charitable corporations under Chapter 180.
I just wanted to, in each of the clubs, they are selling liquor, correct?
All of them have liquor licenses.
And they are selling food, correct?
No, none of them sell food.
None of them sell
They
just
provide
liquor.
food,
Some of them have,
peanuts,
no, well, yeah, okay.
pretzels.
Yes,
dogs?
yeah, that kind of stuff, but
Well,
but not sandwiches or
But they have
meals.
victuallers licenses, probably.
The Legion Home does not, the Lithuanian Club does, and occasionally they will prepare dinners and banquets and things like that. And
You
people rent
said,
it on used
in your
kitchens.
argument to us, you said that the reason that smoke detectors and carbon monoxide detectors could be required in private homes is because when they're sold and there's something the state is regulating, there's something going on with the public. But in the private clubs that you represent, they all, not talking about any other kind of club that we might imagine, but the ones you represent that are here in this case, they all have liquor license. They're all subject to the common victuals requirements. So isn't that analogous to what you said when a sale of an apartment, of a house goes through? So they've got to therefore abide by the other public health regulations, no smoking.
That's true, and Chapter 270, Section 22 says they have to abide by the no smoking rules when they're truly public, when they're open to the public, when they're rented out, or when there are people on the premises who are not members or guests. They have to comply with that, absolutely. But the state statute created boundaries here, and
It didn't create boundaries, it created a floor. It simply says this is what you have to do, and other agencies can make you do more.
Well, I respectfully differ, Your Honor. I don't think that's a floor. I think that's a boundary. And I think on page 23 of my brief, I cite the Trinell case that clearly says that regulations of a board of...
Smoking may be permitted or smoking must be permitted. I think it says smoking may
Yes.
be permitted. Surely if the legislature had intended what you're arguing for, the simple wording would have been either smoking must be permitted in the following places, or, they want to use it, smoking may not be prohibited in the following places. They did not use either of those formulations, But the classic formulation, it may be permitted, doesn't have to be, but it may be.
That's true, Your Honor, and you have to look at the evolution of the statute. In 1975, the legislature passed the first state statute regulating smoking, and it prohibited it in buses and subways and elevators and supermarkets. And that the public then had a zone or a place where they had an expectation to be no smoking. Later, they extended that to publicly owned buildings, city halls, schools, the State House, state-owned buildings. So now the public had a right to expect in the places they need to go of necessity to go to work, to go pay their tax bill, that they could expect no smoking. In 2004, they extended that another step to say workplaces. And the thrust of this statute was to define a zone of protection around workplaces. Any place that there's an employee on the payroll being paid, people have a right to go there and expect no smoking. But they specifically carved out
But they've set that
private
as the
homes.
state minimum. That's the floor. In these places, not even the towns. The towns can't permit smoking in the places that the state law has already banned.
Correct.
But then it goes on and says, seems to me, that other state authorities, other local authorities may increase these requirements, may heighten them.
Correct.
Smoking may be permitted in these places, but it doesn't have to be permitted if local authorities decide to make more stringent regulations.
But the legislature created a uniform statewide policy that essentially said private clubs are okay to smoke in. And the extension of power by the local board has to be measured against what's reasonable in terms of local concerns, for example. And I cited an example where Gloucester may need a public health regulation to regulate fish handling on public piers, but certainly Northborough doesn't need a regulation like that.
Mr. Tremblay, I'm sure you've read the amicus brief of the Boston Public Health Commission, and
Yes, Your
their
Honor.
position, in a sense, mirrors your argument, but draws a different conclusion. What it says is relatively easy to define employer, employee. We've got all kinds of tax structures. There's no debate about it. Private clubs, different animals. Some of them are incorporated. Some of them are informal. Some of them meet in homes. Some of them meet in buildings where there might be regulations in place. And so what we're going to do, says the Public Health Commission, is what the legislature said, is that's the kind of stuff, we'll leave it up to the local community. They kind of have a handle on their local.
And quite frankly, Your Honor, to be blunt, I think they're wrong.
Okay.
The purpose of the state legislature's action was to create a uniform policy and eliminate what we had before, which was a patchwork situation, where you could smoke in a private club in Hudson but not in Marlborough, where you could smoke in a public restaurant in one town but not in the next one over.
But they, excuse me, if they meant that, they would have gone with an express preemption clause and preempted it. And they do the exact opposite.
But that's
the
where
legislation makes clear that it will not preempt local authorities.
That's where the Trinell case.
It does seem to invite local differences.
That's where the Trinell case and the whole body of law and statutory construction comes into play, Your Honor, because they can regulate in the area, yes, but they have to stay within the boundaries of the statewide policy that the legislature was intending to create. The legislature is evolving this regulation of smoking from 1975 to 2004. They keep making it a little more stricter each year. Eventually, the handwriting is on the wall. I think in another 5 or 10 years, there'll be no smoking in private clubs. But right now, the legislature didn't want to go that far. And by giving them authority not to preempt things, they weren't saying you can go right to that step today. What they were saying was you can adapt this based on local concerns. For example, Marlborough has a facility now called an assisted living facility where you go in and it's not a nursing home. What is it? Is smoking permitted in this place? That would be a very truly unique local concern to the city of Marlborough, Board of Health, to say there shouldn't be any smoking in an assisted living facility because it's one that slipped through the cracks of the state legislature's uniform statewide policy. But a private club doesn't slip through the cracks. That's right there. That's within the boundaries that the legislature prescribed. You're free to regulate, but stay within these boundaries. Otherwise, Your Honor, you render that whole section of the statute meaningless. What was the purpose of the state legislature debating and carving out specific regulations about private clubs and when you can smoke and when you can't, what was the purpose of it if the town of Athol can go and nullify it 5 months later?
Are these Board of Health members elected or appointed?
They're appointed by the Board of Selectmen in the town,
And the Board of Selectmen is elected.
and the Board of Selectmen is elected, correct?
So in effect, you've got a democratic process here. People voted for the Board of Selectmen appointed the Board of Health. The
You
Board
do
of
and
Health says,
you do
okay,
and you
we're gonna-
don't, because Board of Healths are independent, independent entities, and the Board of Selectmen, for example,
Isn't your
can't
remedy
veto.
remedy to kick out the selectmen and then have a new Board of Health appointed?
Right, you have to
Rescind the
go 2
ordinance?
steps, yeah. And in fact, this is what happened in the City of Marlborough case that I cited in my brief. After the Superior Court, Judge Gershengorn entered an injunction to join this regulation, the entire Board of Health resigned. Marlborough had no Board of Health for about 6 months. And in fact, they didn't have a legal Board of Health for an entire year because in a city, you're required to have a doctor on the board. They couldn't find a doctor to do it. I think they finally found a foot doctor. So it becomes comical.
This happened in my city, too, with this kind of regulation, and...
Not in mine.
The members of the Board of Health were actually threatened with physical assault by people.
It hasn't gone that far in Athol, but there has been great dissension and a lot of public upheaval over this. But your question is very important because a Board of Health is not subject to authority or regulation by the Board of Selectmen. They can't veto anything that they do.
I understand that.
Okay, so my final word, this is a very simple case of statutory construction. The action of the board has to be measured with respect to staying within the boundaries of the uniform statewide policy that the legislature created. And jumping ahead as they did nullified and made inoperative entire chunks of the state legislature's act, and it just went too far. Thank you, Your Honor.
Thank you, Mr. Clender.